All right, good afternoon, everybody. For our guests in attendance, my name is Brant Helwig. I'm a member of the faculty here at Washington and Lee University School of Law, and I also have the privilege of serving as the school's dean. And as dean, it gives me great pleasure to welcome all of you to our 61st installation of the John Randolph Tucker Lecture. The Tucker Lecture, our school's most distinguished lecture series, was established by the Washington and Lee University Board of Trustees to honor the memory of John Randolph Tucker, who, when he joined the faculty in 1870, doubled the size of the faculty in one fell swoop, taking it from 1 to 2 faculty members. Before joining the faculty, Professor Tucker had served as the Virginia Attorney General and also as General Counsel for the B&O Railroad in Baltimore. And apart from a brief stint as a member of the United States Congress, Professor Tucker served on the law school faculty until his death in 1897, a period that included a stint as the law school's first dean. Additionally, he served a one-year term as the president of the American Bar Association during the latter portion of his academic career. The Tucker Lecture Series began in 1949, and as indicated on the back of our program card, this lecture has featured a number of prominent academics, jurists, and public figures. Actually, interestingly, the first Tucker Lecture was delivered by John W. Davis, graduated from the law school in 1895, and so was a student of John Randolph Tucker. At the time, some 50 years after he graduated, he came back to deliver the first Tucker Lecture. In keeping with the tradition of highly distinguished speakers, we are pleased to welcome Joan Biskupic, who will speak on the life and power of Chief Justice John Roberts, which she has recently documented in a biography entitled The Chief, The Life and Turbulent Times of Chief Justice John Roberts. I have my copy of it here, but it's not that exciting because it doesn't have a book jacket, but we did have that printed here, so this is what it looks the cover of her most recent biography. Ms. Biskupic, a full-time legal analyst for CNN, has covered the United States Supreme Court for 25 years and is the author of several books on the judiciary. Before joining CNN in 2017, Ms. Biskupic spent a year as a visiting professor at the University of California, Irvine School of Law. She previously was an editor in charge for legal affairs at Reuters, and before that, she served as the Supreme Court correspondent for the Washington Post and for USA Today. In addition to her recent biography on Chief Justice Roberts, Ms. Biskupic's previous books include the following: Sandra Day O'Connor, How the First Woman on the Supreme Court Became Its Most Influential Justice, that was published in 2005. American Original, The Life and Constitution of Supreme Court Justice Antonin Scalia, published in 2009. And Breaking In, The Rise of Sonia Sotomayor and the Politics of Justice, published in 2014. Ms. Biskupic received her law degree from Georgetown University. I learned last evening that she did so attending the evening program while working full-time as a journalist and also while raising her newborn daughter. Ms. Biskupic was a finalist for the Pulitzer Prize in Explanatory Journalism in 2015. We are thrilled to have her back in Lexington, where she has been a frequent patron of the Powell Archives. Please join me in giving Ms. Biskupic a warm welcome. Thank you.
Thank you all so much. And it's true that I have been a frequent patron of the Powell Archives. In fact, for my first book on Sandra Day O'Connor, they were so helpful. John Jacob, who is here, the archivist, I'm so glad to see you, because Sandra Day O'Connor had this wonderful relationship with Lewis Powell, and their correspondence illuminated their lives and helped me with that biography. And I can't help but mention that the dean referred to the fact that while I was in law school, I was working full-time at the Washington Post and also had this baby. Well, that baby, who's now 27, used to come with me to the archives. I would pack her up early in the morning on one day that I got off, and I would bring like a little video player that she could watch. And of course, even though she was getting too old to be wrapped in a blanket, I'd bring a blanket because anybody who does work in an archive knows how chilly it can be. And so when I told her I was coming back to the archive for probably about the 5th or 6th time and doing it as this lecture, she was sort of wistful about the whole thing. But I'd like to thank the dean. I'd like to thank Mary Irvin, for so much of your help on this. I'm glad to see both John Jacob and Tony Losi, my colleague for many years of reporting, in the audience. And I do want to say that I feel especially honored to be part of a series that goes back to 1949 and includes so many people who are still my colleagues in the law and academia and journalism. You mentioned that I had taught I was a visiting professor out at UC Irvine, where Dean Chemerinsky, who's now at Berkeley, was part of, and two of my closest journalistic colleagues, Dahlia Lithwick and Linda Greenhouse, have been here before, so I am quite honored by this list. I like to start with a letter that John Roberts wrote when he was only 13 years old, and that I've used to show how his early character and that he almost always had perfect timing. Shortly before he reached high school age, an elite boarding school was founded in northern Indiana, close to where his family was living. And for those of you familiar with the East Coast tradition of very prestigious boarding schools, they didn't have them in the Midwest. It was very much of an East Coast tradition, and especially the Catholics didn't have them. And John Roberts was being raised Catholic, but this was a very elite Catholic boarding school founded near his home. And he wanted to attend this school, known as La Lumiere. So on December 22nd, 1968, when he's only 13, he sits down to write a letter to a man by the name of James Moore, who's the headmaster. And I found this letter under glass at the school. Dear Mr. Moore, the main reason I would like to attend La Lumiere is to get a better education. I've always wanted to stay ahead of the crowd, and I feel that the competition at La Lumiere will force me to work as hard as I can. At an ordinary high school, it would be probably easy to stay ahead. I realize that going to La Lumiere will mean a lot of study and hard work, but I feel confident that these labors will pay off in large amounts when it comes time to apply for college. I am sure that by attending La Lumiere and doing my best here, I will assure myself a fine future. I won't be content to get a good job by getting a good education. I want to get the best job by getting the best education. Sincerely yours, John Roberts, Jr. Now, young John Roberts was accepted, of course. He was so serious and focused at an early age that an aunt of his told me fondly that he was known as Sober Puss. And she said, very fondly, and I made that point in the book. It was not derogatory. He graduated first in his class at that prep school, La Lumiere. He then went to Harvard as an undergrad, completing his studies in just 3 years. Then he went to Harvard Law School, where he earned high honors again and was managing editor of the Law Review. Before I give you more of his personal story and life in the law, I want to observe that he is only the 17th Chief Justice of the United States. We have had 45 presidents, but only 17 Chief Justices. And that points up the importance of his office. I'm going to address what I learned about him as I did this book and research, and especially where I think we're going to go now at this very pivotal point in Supreme Court history, and frankly in American history as well. After life at La Lumiere and then Harvard College, John Roberts graduated from Harvard Law School. And again, speaking of good timing, his brand of conservatism was on the rise. Now remember, he came from a sort of insular life in northern Indiana in a place called Long Beach that had been a vacation area for people in Chicago. He'd gone to this very fancy school where he got a terrific education, and then went to Harvard and bristled at the liberalism that was on campus then. Still is on campus, of course, but then there was a much more of a greater contrast. It was right after Vietnam, and there were still lingering Vietnam protests. A lot was happening there at Harvard. It was a time of affirmative action, policies that made young John Roberts bristle. But fortunately for him, just as he's graduating from Harvard Law School, conservatism is in ascendance. And we're starting the Reagan Revolution in 79 and 80. So his first clerkship his first two jobs right out of law school were two fine clerkships, one with U.S. Appeals Court Judge Henry Friendly of the Second Circuit based in New York. And Henry Friendly was very much regarded as probably the best appeals court judge of his generation. And then, importantly, John Roberts clerks for then Associate Justice William Rehnquist. This was in the 1980-81 term, and William Rehnquist doesn't become chief until 1986. Roberts goes on to straddle kind of the two worlds of Henry Friendly and William Rehnquist. And I document through my book how he continues to do that, always kind of torn between the judge's judge, lawyer's lawyer of Henry Friendly and more of the ideological William Rehnquist. He opted most immediately in 1981 after his judicial clerkship to follow the Rehnquist model. Roberts joined the Reagan administration and with like-minded young attorneys began to try to roll back liberal-era policies. He got his job, by the way, through Ken Starr. Ken Starr knew him, knew then Justice William Rehnquist through his own clerkship with Warren Burger, and he, Justice Rehnquist, called Ken Starr and said, I have this young man here who's great, who you'd really like to have in the Reagan administration, and that was the first time Ken Starr ever heard the name John Roberts. And those two paths continued to cross for decades. So John Roberts joins the Reagan administration in 1981, and frankly, his first assignment was helping Sandra Day O'Connor in August of 1981 start preparing for her confirmation hearings. But mainly he's working on policy, first in the Department of Justice and then in the White House counsel's office. And he tells people later that what moved him to want this job was hearing Ronald Reagan's 1981 inaugural address. You know, he's still a law clerk to Rehnquist at this time, but he's listening to Ronald Reagan, and he says, I felt a call to action. I felt someone who was speaking directly to me. So he joins the administration, and he's just so enthusiastic about their policy agenda, and he writes to Henry Friendly, who remains a mentor of his, and he says, this is an exciting time when so much that has been taken for granted for so long is being seriously reconsidered. And he writes to Henry Friendly about things like affirmative action, things like habeas corpus, things that are so identified with the Reagan era. So John Roberts works for Ronald Reagan, and then he works for Ronald Reagan's successor, George H.W. Bush, and this time he's in a terrific job as the Deputy Solicitor General, deputy to Ken Starr. And he was quite young then. He was only just about 35 when he was tapped for that job. And I interviewed Ken Starr about all these moments, and he said, what he lacked in age and experience, he made up for in savvy and wisdom about just how things worked behind the scenes in the administration from his time with Reagan. So he was a prized member of both the Reagan and Bush administrations. And on January 27th, 1992, the day that John Roberts turned 37, the first President Bush nominated John Roberts to the D.C. Circuit. As many of you know, the D.C. Circuit is widely known as a stepping stone to the Supreme Court. Justice Scalia came from the D.C. Circuit, Justice Ginsburg, Thomas, Kavanaugh, the Chief, all came from that court. So Roberts gets this wonderful nomination. But a man by the name of Joe Biden is running the Senate Judiciary Committee at the time, and he stalls on this nomination. And that's because when John Roberts worked in the Reagan administration, he was essentially under the radar. But once he got to the George H.W. Bush administration, it was much more public. He was signing briefs. The liberal advocates in town knew who John Roberts was. He was not just arguing cases, but he was also working on policy matters. He was screening judicial nominees. In fact, I'd like to mention that the very first time John Roberts and Sonia Sotomayor crossed paths, it was when John Roberts was part of a group that was interviewing Sonia Sotomayor for a district court judgeship. So John Roberts was at the heart of many things, and Judiciary Committee Chairman Joe Biden stalled his nomination. This is all through 1992. And people who John Roberts was working with in the White House said, do not worry. President Bush is going to win re-election. We'll just put your name up again. Everything will be fine. Well, we all know what happened in November of 1992. Bill Clinton wins, and John Roberts has to go back to private practice, goes to private practice for what would become the longest stretch he has there. And he actually earns a stellar reputation as an appellate advocate. But he was quite dejected. He thought he would be defined by this loss. This was the worst thing that had happened to him in his life, that he had lost out on this nomination. If we have time, but it was in many ways, of course, the best thing that had happened to him, because he then becomes this, the gold standard of appellate advocacy. And if we have time at the end, we might talk about how John Roberts is actually quite shy and reserved in many public occasions, and he had to learn to calm his nerves, to stand at the lectern and address the justices, as I say, to become someone who was held up as the model of appellate advocacy. So flash forward to 2003, he finally makes it onto the D.C. Circuit, appointed by the son of the president who first tried to put him there. George W. Bush tapped Roberts for the prestigious court. John Roberts had worked with many other lawyers of his generation down on Bush v. Gore, and he was quite positioned for that. So he gets on in 2003, and just 2 years later, when he's only 50 years old, he's nominated to succeed retiring Supreme Court Justice Sandra Day O'Connor. Certain circular theme there after having helped Justice O'Connor. And it also showed what a springboard the D.C. Circuit was. Yet before his confirmation hearings could be held in 2005, Chief Justice Rehnquist dies. He dies of thyroid cancer. And a confluence of events, including public outrage over how the George W. Bush administration has handled Hurricane Katrina, prompts the president to switch Roberts' nomination from this associate justice spot to Chief Justice William Rehnquist's spot. And he becomes, this is how, it doesn't seem surprising in retrospect, but at the time he was only 50, and he is the youngest person to be nominated to the Chief Justiceship for 200 years, since John Marshall. So if that chronology and overview had kind of a lightning fast tone, it's because that's what actually happened to him. He goes from thinking that his professional life is really on the outs because he loses the D.C. Circuit post, to suddenly he's there in the center chair of the Supreme Court. So it was just about a decade between when he lost the D.C. Circuit to when he got there. And it shows, just again, how he was in the right place at the right time. But crucially, he also was able to rack up 39 oral arguments before the justices at that point. And John Roberts quips that he certainly got better as an advocate after he became chief, because people now talk about it so much. But he really was. He was really a strong. Preparation was everything for him. He was notorious for working with index cards, which somebody has left a prop down here for me. Working with index cards and reshuffling them so that he could reshuffling so that no matter what question he got, he could segue back to his main points. But one other thing I should mention that I have included in many stories, he was always worried about freezing. So he would write at the top of his legal pad, "Mr. Chief Justice, and may it please the court," which was the first thing that he's supposed to say, just because he was so worried he would freeze. But of course he never did. So he becomes Chief Justice at this very young age. But talk about good timing. From the start, he has a conservative majority on this 9-member bench, and he's able to stake out unflinchingly conservative positions in most areas of the law. Just to refresh your memory, most notably, he wrote in 2007 the parents-involved decision that invalidated public school integration plans in Louisville, Kentucky, and Seattle, Washington. And then he also writes the 2013 Shelby County versus Holder decision that curtails the reach of the Voting Rights Act. I feel like Shelby County has so defined the Roberts Court, but oddly enough, Shelby County actually was what gave rise to the notorious RBG meme, because her dissent in the Shelby County ruling in 2013 generated a lot of liberal interest on the internet, and a young woman who was at NYU at the time created Notorious RBG and attached it to the dissent, and obviously that took off like nothing else. So people can't get enough RBG apparently. But the majority opinion was John Roberts, and he had felt. I believe that a lot of his views were trace at least to his time in the Reagan administration. And he believes that government remedies tied to race, whether they be public school integration plans, or university affirmative action, actually hurt African Americans and other racial minorities. Now, this has generated a serious clash on the court between him and some of the more liberal justices, especially Sonia Sotomayor, who was our first Latina justice. For example, when Justice Sotomayor referred in 2014 in a Michigan case to how racial minorities might feel, I do not belong here, the Chief responded, well, maybe it's racial preferences that make them have that doubt, and that doubt can be debilitating. So that has remained a real fault line there. John Roberts has long believed the colorblind notion of the law as it was defined in the Reagan years and beyond. He was also part of the bare 5-justice majority that produced Citizens United versus the Federal Election Commission. And as many of you know, that 2010 case lifted limits on corporate and union money in elections. Roberts was also part of the 5-justice majority. Again, these are all just bare 5-justice majorities that broke major ground on the Second Amendment when the justices declared for the first time that an individual right to bear arms in the case of District of Columbia versus Heller. Now, both of those landmarks, Shelby County and Heller, came with the vote of Justice Anthony Kennedy. While Kennedy served for 3 decades and was a reliable conservative, when the court shifted to the left, it was because of his vote on social issues such as gay rights, abortion, and affirmative action. Roberts often took a strong stand in opposition to those cases, and most conspicuously that happened in 2015 when he used his first, and so far only, oral dissent from the bench to protest the majority decision that declared gay marriage a fundamental constitutional right. Roberts complained in his dissent that the majority was infringing on an issue that should be left to legislators. He said, just who do you think we are? This is a court. Just who do we think we are? He was referring to his colleagues. This is a court, not a legislature. We have to say what the law is, not what it should be. And many people forget that he was so angry about that he actually compared what the majority was doing in that case of Obergefell versus Hodges to Dred Scott, which is probably the worst thing you can say about a ruling. There is one major exception, however, to the conservatism that helped define John Roberts in the public eye during the early years of his tenure, and that was the 2012 dispute in the Affordable Care Act case, NFIB versus Sebelius. In that case, he saved the Obama-sponsored healthcare overhaul from being struck down. But that decision came only after the Chief Justice switched 2 key positions, angering conservatives and baffling liberals. And this is something I really tried to get to the bottom of in my book. We had all suspected, in part through reporting right after the decision that CBS reporter Jan Crawford Greenberg had found about how angry some of the conservative colleagues were that he ended up voting for the individual insurance mandate. But what I found in the course of my reporting is that there was this swap, that he actually first had voted against that, but had voted for the Medicaid expansion, and then reversed both votes. And it came after many weeks of negotiation, but in the end he shifted on both those parts to find the core of the law, dubbed Obamacare, constitutional, but declared the provision expanding Medicaid coverage to find that unconstitutional. And two other justices sort of worked with him, not sort of, they actually did work with him behind the scenes, Justices Breyer and Kagan, to come up with this compromise. So the final tallies, 5-4 to uphold the individual insurance mandate and 7-2 to scale back Medicaid for millions of people at the poverty line, came after weeks of negotiations and trade-offs among the justices. And, you know, the final rulings have reverberated in the public arena since. I can tell you exactly where I was in my life, where I was standing when I got the tip about the flip in the Medicaid part of the ruling, because I thought, aha, no one knew about this. So that became quite a sleuthing adventure when I tracked that down and was able to get people inside the court to actually go back and look at vote counts and what people had said. Anyway, it's notable for purposes today that that case marked, until this year, the only major time that John Roberts had gone over with his liberal colleagues, the four justices on the left, to form a majority and leave his fellow conservatives in dissent. And I have to note that when I was researching the Affordable Care Act decision, that I was surprised to find out that episode, first of all, I believe it crystallized some distrust that the chief experienced from his colleagues, and that was building up to 2012 and has lingered since. But yet I do want to stress that to his supporters and to many people outside the court, it's that one vote that has people thinking that that he will be more moderate, especially now, and that he isn't just someone who can be easily identified as a former Reagan acolyte or as a George W. Bush appointee. But it did, I have to say, as a journalist, I had actually predicted in 2012 that he would be in the majority to uphold the individual mandate, but I wouldn't have guessed that it would have come after a switched vote. I thought that he was already there, so I was wrong. But as Justice Ginsburg told me in 2012 when I was trying to figure out what happened, it ain't over till it's over. Things are very fluid behind the scenes. So likely Roberts' action in the first healthcare case was born of a concern for the court's legitimacy and its own legacy, as well as intertwined with his concerns about his own legitimacy and legacy. And however the Chief Justice would explain it, and he would not explain it beyond what he said in his opinion that was tied to the congressional taxing power, if you recall, those moves back then added a new dimension to the man who would insist that he always decided cases based on the law, or as he said in his 2005 hearings, as an umpire calling balls and strikes. Now, although it is sometimes lost in subsequent accounts about how the chief straddled the middle, he did undo a key part of what Congress was trying to undertake here with providing more health care coverage to the poor. So that's something that, as I said, is sometimes lost. So that case stands out for about 7 years. But now that we're in a new chapter of the chief's tenure, and that's, I really use 2018 as a dividing line, the post-Anthony Kennedy court. That episode from 2012 has more relevance, I believe. Since mid-2018, Roberts has not only been in the center chair as the Chief Justice, he's been at the center in terms of ideology. And I think the closest comparison we would have would be that of Chief Justice Charles Evan Hughes, who presided during the Great Depression and as President Franklin D. Roosevelt was trying to solve the nation's economic problems with his New Deal initiatives. Hughes served first as an associate justice, like the old chief, but it wasn't, there were two separate stints, 1910 to 1916, and then he came back to the court to serve as chief from 1930 to 1941. And Charles Evans Hughes also took the lead for the third branch to forestall FDR's 1937 court packing plan. Today, politicking in Washington has only gotten more tumultuous, and I think for the current chief, the threat to the integrity of the court really matters, and I think it also plays into some of his rulings. A related factor for using 2018 as my dividing point is the fallout from the hearings for Brett Kavanaugh. Those were so volatile, and Brett Kavanaugh and John Roberts have been old friends, and they have a lot in common. And I think that whole episode has again reinforced the current chief's interest in trying to make it look like this is a court that's above politics. So right after the confirmation of Brett Kavanaugh, you might remember that John Roberts spoke at the University of Minnesota, and it was going to be a Q&A, and he decided to ask the dean if he could just make a few minutes worth of remarks. And it was then that he said, "We do not sit on opposite sides of an aisle. We do not caucus in separate rooms. We are different. We don't serve one party or one interest. We serve one nation." And then it was just a month later that he issues a statement, first given to the AP and then to all reporters, where he countered a Trump complaint about an Obama judge, quote from President Trump, an Obama judge who had ruled against the administration in an early asylum case. And what does Chief Justice John Roberts say? "But we do not have Obama judges or Trump judges, Bush judges or Clinton judges. What we have is an extraordinary group of dedicated judges doing their level best to do equal right to those appearing before them." Now, I remember very well when this happened. It was right before Thanksgiving, and I had to quickly, do a couple segments for CNN, and some of the anchors were saying, "But Joan, you're always referring to who appointed these justices." And I said, "Yes, I do. I do name them as an Obama judge, but I don't." The president was essentially saying, if you're a Trump judge, if you're an Obama judge, you're automatically going to side with the cause that the administration would want. And while I do have to say, and this is, I'm sure even the chief would not agree with this, but you can tell a lot about a judge or justice by who appointed them. Of course, these people go through all sorts of extensive screening. Merrick Garland was not going to be picked by Donald Trump, but he was picked by Barack Obama. And he didn't get through, of course. But, it just goes to show that it is about politics. But once a jurist is on, I do not think that it's true that they can be counted on automatically decide with the interest of the president who put them there. And that's essentially what President Trump was saying, and that John Roberts wanted to counter. So you have him putting those statements out there. And then John Roberts puts his votes where his mouth was, to an extent. In February, just of this year, he cast the fifth vote, siding with the four liberals, to block a restrictive Louisiana abortion regulation, at least temporarily, from taking effect. Now we know John Roberts has never voted on the merits against an abortion regulation. He never has found one, either in majority or dissent, that he would disagree with. But in this case, the disputed law was similar to one from Texas that had been struck down in 2016. And Roberts had actually even dissented in that case, but for one reason or another, he decided that early February was not the time for suddenly a similar abortion restriction to take effect. Just to close the loop on that one, that case was June Medical Services versus G, and that's going to be argued on the merits now in early 2020, with a decision probably coming in June, right in the thick of the current presidential campaign. So I do believe that kind of atmosphere will affect the chief one way or another. Probably the most important move that John Roberts made in the realm of compromise here came in the recent census case, when the Trump administration wanted to add a question about citizenship status. Now, the court ruled 5-4 against this effort, with the chief casting the decisive vote. But he was working with two different sets of justices. First, he laid out why Commerce Secretary Wilbur Ross had significant latitude to add a new question. He was joined in this part of the opinion by the four conservative brethren on that point, but then he swerves right toward the end of the ruling and joins his four liberal colleagues to say that Ross's justification for the citizenship question tied to enforcement of the Voting Rights Act was contrived. And I believe that was probably my cell phone going off, so I apologize. But it wasn't too loud, at least. But I discovered this summer and confirmed with the justices only after really, really hard work this summer that Roberts' vote on this came with a switch. Again, he had changed his position behind the scenes. Now, just to remind you of the context of this case, in proposing to add the citizenship question to the full census, Wilbur Ross had said that it was necessary because the Justice Department wanted this data to enforce the 1965 Voting Rights Act. But, multiple cities, states, and civil rights groups sued, saying the question, in fact, about citizenship would have people not want to answer the question, and the response rate would be lower among new immigrants and likely people of color. And that would, of course, not only skew, reapportionment, which is tied to the census, but also a multitude of federal programs and federal funding, again, tied to the census. After a trial on this issue before U.S. District Court Judge Jesse Furman up in New York, which found that Ross had actually contrived the rationale and had failed to follow the Administrative Procedure Act guarantee of or prohibition against arbitrary and capricious agency choices. Furman said that this was just a pretextual reason for it, and he said that DOJ didn't really want the request, that Wilbur Ross had gone out and solicited DOJ's input and had been dealing with people like Steve Bannon with the Trump administration to do this. And Furman says, in his opinion, perhaps most egregiously, the evidence is clear that Secretary Ross's rationale was pretextual, that it was not the real reason for his decision to add it, and namely, he cannot keep claiming it was to enforce the Voting Rights Act. The Trump administration decides to appeal directly to the Supreme Court. As those of you who are lawyers understand, typically you go to an appeals court first, but the Trump administration goes right to the Supreme Court and says, we want the census forms have to be printed soon, please take this up. And, President Trump was pretty confident that the Trump judges, that he was going to be okay. And here's what we saw publicly. This is what we were all left with. During oral arguments, John Roberts suggests that there were indeed grounds for adding the citizenship question, and he even asks about the Voting Rights Act. And he talks about how a citizenship question had been asked in other forms before 1950, and so he's saying things that could be taken as being positive toward what Wilbur Ross did. And the Chief Justice doesn't question at all whether this was a concocted justification. In fact, the only person who used the word contrived during the entire hearing was Justice Kagan, who said, you can't read this record without sensing that this need for this question has been contrived. But nobody else jumps on that. And the advocates themselves had, I interviewed them this summer where I was trying to figure out what really happened. They had decided among themselves that they did not want to challenge John Roberts and the rest of the justices by essentially saying Wilbur Ross lied. They decided to just stick to what federal procedural rules require and to say that Wilbur Ross failed in that way. They didn't want to say he made the whole thing up. But so we're watching all this, and most commentators and news reporters then say it looks like it's going to be 5-4 with this court ruling for Wilbur Ross and the administration. But sometime in the weeks that follow, John Roberts begins to waver. And this is what happens. He begins to believe that Ross's rationale for the citizenship question has been invented. And despite the deference that he normally would give to the administration, and the deference that this court is going to give to the administration for lots of things is going to be quite high, he decides in this case it matters, and it's going to matter in the final judgment. And, I took it as my challenge to find out exactly what happened, because in going through Justice's archives, including here, I have seen how fluid things can be behind the scenes, that the justices change their positions, sometimes subtly in terms of the rationale they have, and sometimes with outright switches, and that's what happened here. And in doing my reporting, I found out about two switches. One was in the census case. The other came when, if anybody I don't know if anybody would have had reason to follow a case by the name of Gundy versus United States that came out 5-3. Justice Kavanaugh didn't participate in that. That's why there were only 8 votes, because it had been argued on the second day of the term, and he was not yet on the bench. But in that case, it was 5-3. in a dispute over the validity of a federal sex offender registration act case. And the justices initially voted behind the scenes to strike it down and to undercut what Congress's delegation power, which has been a real project of some of the more conservative justices. But 2 justices switched in that case. The chief wasn't one of them. So, that was fun to find out too. You kind of live for these moments. But in the census case, on the very last day of the term, June 27th, John Roberts shows his hand. But it's not without some suspense. And I want to mention, there are a couple of people in here who've done journalism. I am one of the lucky reporters who can still go up to the Supreme Court courtroom and hear the justices announce their opinion. Because of this, how people really want to know immediately what happens at the court. People are quickly, on their iPhones at 10 o'clock on a court day. Most of my colleagues have to be down in the press room ready to get the paper that's distributed with the public information officers and quickly typing up what happened. Someone like me, because I've, since from my time at Reuters and now at CNN, I'm sort of our second person doing more analyses rather than kind of just the facts of the case. So I can sit up there and listen. And so I'm listening to John Roberts, and this comes after the gerrymandering case, which I'll mention in a second. And I'm hearing him talk about how, well, actually, I'm going to reverse him and put you guys in the courtroom. So here it is, the very last day of the term, and the 2 cases that they're about to announce are the partisan gerrymandering and the census one. And in partisan gerrymandering, both of them are so politically charged. In the gerrymandering case, because right now so many of the state houses are run by Republicans, the idea of entrenching the people who have control of these state houses, you're entrenching Republican partisan maps, and it's hard to have Democrats break through it all. So that was a very hot case. And then, of course, the census case also had a lot of strong partisan overlay. And first, the chief announces the majority opinion in the partisan gerrymandering case, saying, we're not going to resolve these disputes. No court can look at whether these things are valid or not. It doesn't matter that they're so extreme. It doesn't matter now that computers and very intense polling data can tell you, the map drawers how to draw lines to keep the incumbents entrenched. It was the 5 conservatives. We're going to say these are not justiciable. These are political questions. And Elena Kagan, speaking for the dissenters, you can all hear this now online. The oral dissents are now available. Says, what a terrible decision, what a bad time in America for the court to throw up its hands and say, we can't be part of this, because lower court judges are coming up with standards. They can do it. So, I'm sitting in the courtroom. I hear this very partisan charged opinion being announced by the chief. It's 5-4. The 5 conservatives, 5 Republican appointees against the 4 Democratic appointees. And now he's about to announce the census case. And I know he's so aware of how the public could view this court as being, just a tool of Republicans. And he starts to talk about how much latitude Wilbur Ross has, how Wilbur Ross can, any commerce secretary, any head of an agency gets plenty of deference to do what he did. And we're about 2/3 into the announcement, and I'm actually thinking, how is this going to work out? Because in both of these cases, he's doing something that I know, and he knows, I know that he knows that he knows, that commentators are going to seize upon and say, oh yeah, Chief, there are no Trump judges, there are no Obama judges, that kind of thing, because you're exactly about to divide, again, as you did in partisan gerrymandering. And all of a sudden he changes. All of a sudden, as I say, about 2/3 in, and in the opinion, I think it's like a 29-page opinion, and on page 23 is when he swerves. All of a sudden he says, the administration has not violated the enumeration clause of the Constitution. It has not violated the Administrative Procedures Act. He said that we are going to broadly defer to the administration as it devises the census form. And then he goes, provided the justification is truthful. He says to accept Secretary Ross's explanation, grounded in the Voting Rights Act, would essentially let us be duped. He says there's a significant mismatch between the decision the secretary made and the rationale he's provided. And he quotes Judge Friendly, who I referred to earlier on. He says, our review is deferential, but we are not required to exhibit the naivete from which ordinary citizens are free. So he was convinced. A couple justices worked on him behind the scenes saying, look, if you buy this rationale that we've all seen now just is not plausible, you will look like you're just doing his bidding. So the 4 conservative justices dissent on that part of the opinion. Justice Clarence Thomas writes for himself, Neil Gorsuch, and Brett Kavanaugh, and he says, I do not deny that their dissent was very much against Judge Furman and the way Judge Furman had held the trial. And he's speaking of Judge Furman here, where he says, I do not deny that a judge predisposed to distrust the secretary, Wilbur Ross, or the administration could arrange these facts on a corkboard and with a jar of pins and a spool of string, create an eye-catching conspiracy web. But that's not what happened. So, and then Donald Trump gets into the action right after it's released and says, can anyone really believe that as great a country as we have cannot ask whether someone's a citizen? Only in America. So, but John Roberts' decision actually, in theory, allowed Secretary Ross to go back and come up with a new justification. And for several weeks in July, the administration tried to do that, but on July 11th, Trump announced that he was dropping the plan to modify the 2020 long form and that he would seek citizenship information through other federal data collections. Now, of course, John Roberts' action in this case recalls what he did in 2012 when he saved the Affordable Care Act case. And once again, here's the chief, an appointee of President George W. Bush and a reliable conservative siding with the liberals in a dispute of immense national significance as it goes down to the wire. So, this adds yet another dimension to how do we understand this man in the Senate center chair, and how much deference will he give to the Trump administration and its most controversial policies. I think he's become harder and harder to predict. I have to say, overall, on the whole, Roberts has given the Trump administration great leeway. A year ago, he accepted the administration's arguments for the travel ban. And earlier this year, he voted to allow the administration to ban transgender people from serving in the military. That was an order in stopping a challenge to block the policy from taking immediate effect. And he's allowed Trump to use military funds to build the border wall. Again, these aren't on the merits, but they're on letting the action go forward. And just last month, he let limits on Central Americans seeking asylum at the southern border to take effect. Overall, he has tried to protect the reputation of the judiciary and to counteract what might be seen as predictable moves. So I think we're always going to see different cases sort of in tandem here. As I suggested, but I want to say outright that, all 5 of the conservatives were appointed by Republican presidents, all 4 of the liberal justices by Democratic appointees. And, again, I don't think we can ignore that those 2 last cases were paired and came down on the last day, the gerrymandering one and the census one. So it's kind of like he's keeping an eye to how he might be seen in total. And finally, I want to say that John Roberts did not leave the administration empty-handed. A lot of the language that he wrote about deference to agency leaders will be relevant in the case that they have in what's known as DACA, the Deferred Action for Childhood Arrivals, that will be heard on November 12th, because DOJ has already used in its briefs language that the chief used in the census case, talking about how a court may not substitute its judgment for that of an agency. It can't second guess. So, he also says, as long as they're within the range of reasonable options. And, the other side invokes them too. And what I've concluded is what's ultimately found to be reasonable, to use a key term from that litigation and this new litigation in DACA, remains in the hands of a Chief Justice who, when I was doing my research, I found him so personally enigmatic, but now he's become similarly inscrutable on the law. I will close with something John Roberts has said about his own possible legacy. Before he went to law school, he thought seriously about earning a PhD in history at Harvard, and he has remained a student of history. And this is what he said in one speech earlier on. You wonder if you're going to be John Marshall or you're going to be Roger Taney, as he referred to the great Chief Justice, revered as the forefather of judicial review, and of course the Chief Justice who was reviled as the author of Dred Scott. The answer, the Chief Justice John Roberts said, is of course you are certainly not going to be John Marshall. That was a slip. That was a slip for an indecisive guy there. Okay, let me read that whole sentence again. The answer, of course, is you certainly are not going to be John Marshall, but you want to avoid the danger of being Roger Taney. That's interesting. Are you going to be John Roberts or not? But anyway, John Marshall versus Roger Taney. So he's watching for how he will be perceived. Thank you, and we've got about 8 minutes for questions, if anyone has any. Yeah. Oh, yes.
There seems to be a potential constitutional conflict emerging between the Congress's right to subpoena members of the administration and the president, insisting instead that executive privilege shields them. Is this going to come to this?
Yes, in fact, that's a great question, because what I've tried to do for people, I love, the Supreme Court is really my area, but with everything so hot about impeachment and the Trump administration, I have dipped fairly regularly into that area. And once a week I try to do a story that tries to make clear some of these issues. And there are there's essentially two kinds of litigation percolating here. One that the courts can decide, and one that the House and Senate will decide as impeachment chambers. And the ones that would go up to the Supreme Court are ones that we've just been hearing about. Last Friday, there was the ruling by the District Court Judge Burl Howell in the matter of subpoena over getting all of Robert Mueller's grand jury materials. And the judge ruled for the House, the Democrats who are trying to get this information as part of their impeachment inquiry. And she essentially said, and this case started before Nancy Pelosi even said we are now officially in an impeachment inquiry. This had started earlier with some of the House committees doing their investigating. But Judge Howell said, they're in impeachment as far as I'm concerned. And as far as I'm concerned, this is part of a judicial type of exercise that the House should have access to these materials, because they're not going to be able to make an informed judgment on what to do unless they have access to this. And just today, just probably as we were all heading over here, the administration announced that it's going to appeal that to the D.C. Circuit. So that's going to go to the D.C. Circuit. We already have at the D.C. Circuit the case over Mazars USA, the longtime accountant firm of Trump, where the House is trying to get 8 years of financial data, and a D.C. Circuit panel led by Judge David Tatel ruled the previous week for the House, saying the House should have access to this. And Donald Trump's most recent appointee to the D.C. Circuit, Naomi Rao, had a very strong dissent saying the House should not have access to this material unless it's in an impeachment proceeding that has essentially been voted on, something much more formal. So that's in the D.C. Circuit still, because the administration has asked that to be heard en banc. Meanwhile, up in the Second Circuit, there's another, the Southern District of New York has a grand jury going where they're trying to get material from Trump. And so those are the cases that are going to go up to the Supreme Court. They're definitely going to, one way or another, the court could always say, we won't hear it. They'll issue an order, but that's where those cases will be appealed to. Separately, though, whatever happens in actual impeachment, if the House were to vote to impeach and the Senate were to have a trial, the last word on that is not the Supreme Court. The last word on that is the Senate, and a case from 1993, which I like to refer to as the other Nixon case, Nixon versus U.S., which involved a judge who had been impeached, Walter Nixon. That case stands for, under this 1993 Supreme Court precedent, that, again, it's a political question. Whatever happens in the House, whatever happens in the Senate, in terms of actual impeachment and trial, stays with the legislative branch. John?
How collegial are the current nine justices? I mean, the public assumes that they loathe each other, the various sides, and the line of the court is always, we have philosophical differences, but we get on just fine.
Oh, yes.
What's the truth?
Well, some of that is definitely true, and they would say that if they were all here right now, they would say, it's so true, we so like each other. We like each other really, 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 kind of, they say that. And I think, that they're appointed for life, so there's an incentive to get along, definitely. But like any other group of 9, they have their differences, they have their little factions, they break away, they roll their eyes a lot at each other, So I don't think I had to actually answer the following question in the book. Is it worse than at other times? Chief Justice Rehnquist was known, had a little bit better reputation among the justices on a personal vein. Not, he was, hard right conservative, so people had problems with some of his rulings, but he was a little bit more like live and let live kind of thing. And he also, I'd like to remind people, he had the advantage of having been an associate justice for 14 years before he became chief. So could you imagine becoming dean, having never been a professor, and then, just suddenly thrust into that, and all the, you don't know where the bodies are buried. But Rehnquist knew how everybody acted, what they were all like, and Chief Justice John Roberts comes in, and these guys these justices had been together for 11 years. Like, they had certain ways of operating, so I think it was tougher for him. But I think that he, as I said, I think there's definitely good fellow feeling, especially if someone from the outside criticizes any of them. They'll say, oh no, oh my gosh, there were some tensions definitely with Judge Gorsuch when he came on, and the whole thing with the Brett Kavanaugh hearings has, caused some internal, just wow, what's happening here among the justices. But once both of them, were part of the family, so to speak, they wanted groups such as yours, they wanted reporters to know, we are all so happy to be together. Which is, I think that's a pretty normal response. Yeah.
So to a large extent, you talked about how he shifted sort of as an intentional point because he's an institutionalist, but is there also a sense that he's sort of exactly where he was and he's just sort of shifted because the frame has now moved right?
I think that's an excellent question, because the court has Justice Kavanaugh has a much more conservative record compared to his predecessor, Justice Kennedy. So yes, it gives him, I still think he is inching to the left, like on that abortion vote. I just cannot see that he would have, well, he didn't do it before, but I think with the court a little bit more to the right, he feels more of a need to try to stake out a position at the center. But that's, the questioner asked about the court moving rather than the individual justice moving. That's what the late Justice John Paul Stevens always said. I stayed exactly where I was. What about them, Because he was a 1975 appointee of Gerald Ford, who became like a liberal Pole, So anyways, things are very fluid up there. And to quote RBG, who everybody wants to quote, it ain't over till it's over. Who was quoting, of course, Yogi Berra. So thank you all.
Joan, thank you very much for providing such an outstanding window into Chief Justice John Roberts' background, his current tenure on the court. We've got a small parting gift. We usually load people up with W&L law paraphernalia. This time we took a different approach. It feels a little bit like Valentine's Day, but we got some chocolate from the local chocolatier. We're happy to get you some W&L stuff as well. But please join me in thanking Joan Biskupic again for such an outstanding job. Yes, thank you very much.